That the motion be agreed to. Charles Chauvel.
Thank you, Mr Speaker. Mr Speaker, I don't disagree. I don't think anybody disagrees with the Minister's contention that criminal proceedings need to be speeded up. And to that extent, it is appropriate to welcome this bill as it's read a third time in the House, because it is true that many of its provisions will lead to an expedition of criminal processes. The bill is better, as the Minister says, for the amendments that have been made to it. And those amendments in particular, the ones I want to mention, are those that flow from the Minority Report, which was filed after the Select Committee process and tabled in the House on behalf of the Labour Party. In particular, we insisted on recording our objection to the proposal to severely curtail the right to silence, and we also objected greatly to the proposal in the bill that would have made it easier to try people in absentia. Both these proposals are foreign to our tradition and our freedoms, and I'm very proud to be a member of a party that stood against those proposals from the outset. The bill would also have been better, sir, if we'd seen some of the supplementary order papers that were moved in the Committee of the Whole not ignored by the Minister. For example, I put up a proposal that would have created a statutory basis for the current judicial practice of giving sentencing indications, something that in itself does save time but doesn't introduce, as far as I'm aware, any great unfairness. Similarly, I put up a proposal that would have codified the practice of giving the defence 21 days to respond to disclosure on the part of the Crown. As I explained during the committee stage, at the moment there's no such time limit, and so what happens is when the defence gets disclosure from the Crown, in order to buy time to respond to it, the general practice is to enter a pro forma not guilty plea. Guess what this means? It means delay. It means more time and more expense in the court system. It means all the things that the Minister says that this bill is designed to prevent. Sir, I don't think there's anybody in the House who doesn't like the Minister or who wishes him anything but the best in his retirement. But he's shown a closed mind on criminal law reform. He vetoed the supplementary order paper on the basis of the government's fiscal position, the one that I just referred to. He only agreed to the further amendments that I've referred to in my speech that were contained in the Labour Party Minority Report because of raw politics. That raw politics is that the Māori Party and the ACT Party took a long, hard look at the bill as it came back from the Select Committee and very properly decided that the objections that had been recorded by the Labour Party were right, that they should also join in with those objections and deprive the Minister of his numbers to pass the bill. And I should say that the Green Party, to their credit, opposed the bill from the outset because that was their way of recording their objections to the matters that I've outlined. So instead of what should have happened, according to our parliamentary rules and procedures, instead of these changes that were proposed being carefully considered in the Select Committee, advised on by officials, and being offered the assistance with drafting that might be required through an agreed process, we saw a closed negotiation process occurring between the parties. Now, as it happens, I think the outcome has produced a better bill, as I've said, but I do deplore the process, and the process stems from the fact that the Minister only countenanced amendments to what he had decided to do on the basis of his officials' advice because he lost the numbers to ram his proposal through. I could compare that approach, sir, with other approaches that have been taken in the Minister's portfolio area. I recall the evidence given by the New Zealand Law Society at the Select Committee about the best way to deal with criminal procedure reform. The Law Society reminded us that the right place to start was with the drivers of crime. Now, we've just lost a major opportunity to deal with a big driver of crime, alcohol, by failing to take a comprehensive approach to reform in that area. We have a Drivers of Crime project, apparently, going on, but it's a closed process. Not many parties in this House and not many people out in the general public would know much about it. It isn't the sort of process that you would expect to be occurring if we were serious about taking a long, hard look at what does cause crime in our society. Then the Law Society said you'd look at the substantive statutes. The Crimes Act dates from 1961, the Summary Offences Act from 1957. They need to be overhauled. And only then, once you've dealt with the fundamental drivers and then the substantive law, might you turn to the issues of evidence and procedure that this bill tinkers with. And that's my criticism, sir, of what we're doing today and what the Minister has achieved in his time in the role as Minister of Justice. Because he has been distracted. He hasn't followed a coherent and attractive reform agenda. He's allowed us to be diverted onto questions like three strikes legislation, boot camps, depriving inmates of the right to vote. All things that won't make a jot of difference to the public safety of our fellow New Zealanders, while the most important statute on the order paper, the one that gives the police powers and controls over how they deal with surveillance warrants, was allowed to languish for more than a year, despite the fact that my colleague David Parker wrote to the Minister and offered him support with a couple of tweaks to pass that bill. So, sir, I do commend the bill to the House. As I say, it is better than it could have been. It's not as good as it might be. And it's not comprehensive reform. We must not kid ourselves about what we're doing here. We will be back in this House in the next term trying to deal with inefficiencies in the criminal justice system because of the failure of the Minister to follow the Law Society's advice and start at the beginning with root and branch reform, rather than in the middle and looking at procedure. We could have had a great Minister of Justice in Simon Power, despite his short tenure in the role, if he'd just listened and put together a comprehensive reform agenda rather than a piecemeal one, such as the one that we've seen over the past 3 years. And that's the great regret I have about the Minister's turn in the job.
Chester Borrows.